So we're going to kick off our program now. Our first segment is how to prepare for a successful closing. I'm going to invite our panelists up to the stage, please. David Maass is going to moderate that panel. Umberto Bonavita is in your program, but unfortunately Umberto was not able to join us this morning. Claudia Casalis from Robert Allen Law is here to join us with that one. I certainly hope, because I haven't seen Claudia yet. Jason Dunbar, Luke Brown Yachts, and Amalia Noguera from International Vessel Documentation. If you guys will please make your way forward. I guess Claudia has not. She's stuck in traffic. She's so lucky she lives in Miami. David, I'm going to let you do the lawyer, the moderator. You can do it. All right. Make yourself at home. Thank you.
Okay. Hi, everybody. I guess until Claudia gets here, I will play the role of both the moderator and the lawyer. We're going to be talking about how to prepare for a successful closing. You've got the contract signed, the boat is accepted. How do you navigate the deal through to closing? Some of the issues we're going to be talking about today. First, getting the right people involved, how to put together a team and make sure you have the expertise on hand that you need to close the deal. Second, the closing documents and sort of the formalities involved in making it to closing. Third, what happens with the money, both the deposit and the balance due at closing. And then finally, we're going to talk about sort of a special topic, which is offshore closings, when you need them, why you need them, and how they're documented. So to start off with, we're going to talk about getting the right people involved. How do you know when you need a third-party documentation agent, Amalia, as opposed to an in-house closing agent? How do you know when you need a maritime attorney? So I will start with Jason. Jason, how do you know typically when you need a documentation agent versus just relying on a brokerage's in-house closing agent?
Thanks, David, for the question. In all reality, at this point, you should have known it, prior, based on the size of the boat, the complexity of the deal. But for the purposes of this panel, the yacht broker here, at this point, we're kind of like Ringo. We're just glad to be in the band, so to speak. You guys are now really the ones that are running it. And so if your question is, when is that time evolved that you need to bring in a dock agent? I would say if it's really based on the size of the boat and the titling of the boat. And that's one of the things that maybe you guys want to bring up or mention here, the term title, the definition, how you use it in legalese may be something that you want to explain to these guys, because it does have multiple.
Sure. Well, title has a few different meanings. Title generally is sort of a synonym for the ownership, the legal ownership of the vessel, but there are different kinds of title. There's legal title, which is who actually owns the boat as a matter of law. And then there's record title, in whose name is the boat registered. And then title is also a form of documenting ownership. For example, you have a state registration and state title as opposed to U.S. Coast Guard documentation, which replaces state title. So often if we're dealing with a boat, say a relatively small boat, that's only going to be state titled and registered, there's no need necessarily for an outside documentation agent. If the brokerage has an in-house closing agent who's experienced in dealing with state titles and registration, you can rely on them. And in some cases also for U.S. Coast Guard documentation. In my experience, if you're going with an offshore registry, it's a very good idea to get a documentation agent involved often, even if it's something that we think a brokerage in-house closing agent can handle. We want to get a doc agent involved because we want them, if they're not already have a relationship with the client, to develop a relationship with that client, because when they go to sell the boat, they may be using a different broker. That closing agent may not be involved, and so it's a good idea to have somebody who has a file on that boat, so you're not starting from scratch when it comes to the documents. Amalia, what do you think? When do you feel like you're able to offer a lot of help to people who are closing, sort of at what kind of registration or at what size of vessel?
I think it pretty much is vessel under 79 feet. It's pretty easy for, a documentation company to handle the transaction. When you have larger boats, it's when you really need to get involved with counsel. Because a lot of time, they call us and said, oh, we want you to handle this transaction. It's maybe like over 79 feet, and they expect us to do a lot of the work. So we recommend, at least, in our firm, we recommend that they hire counsel. Because there are certain areas, legalities, that we cannot do. On the documentation side, yes, we can go ahead and do that. But then you have, furthermore, a lot of the duties that have to be done, not by a doc agent, but by counsel.
Because I think there's both how you register the boat once you've decided upon a form of registration, and then also the decision about what form of registration makes sense. Do you want to go offshore? Do you want to go with Coast Guard documentation? I think a lot of times that's where we as lawyers are called in to advise an owner, because that depends not only on what kind of boat it is, but also on how they plan to use it. Where do they plan to use it? Do they want to charter? Things like that. Claudia, at what point do you think it makes sense for a lawyer to be involved in a transaction? When do you think brokers should ask a buyer to get a lawyer involved if they haven't already?
I agree. It's about 24 meters, 79 feet. I think that's when economically it makes sense to have a lawyer involved, but also legally you have a lot more certificates and a lot of requirements that are involved with these types of yachts. Anything below that, I would definitely have a documentation agent always.
And why is 79 feet sort of a tipping point for where a lawyer should get involved?
Well, one is cost benefit, right? It's essentially, once you're buying a boat of about 4 or 5 million, it makes sense to have a lawyer involved. And second, once boats reach 24 meters, legally, they have to have a whole bunch of certificates. And as they get more in length and tonnage, then even more are involved. So it starts making sense.
I often have people who come to me who are buying boats sort of under that 79-foot mark, and say they just plan to U.S. document the boat or state title and register the boat, something very straightforward. They want to get a maritime lawyer involved, but I feel like I have to tell them that it's not going to be cost effective. Given the price point for the boat, given what our fees are going to be, you are better off working directly with a dock agent. If you have specific questions, I'm happy to answer them, but often it is not cost effective for us to handle a transaction from start to finish below a certain point. Okay, so now that we've talked about sort of the people you want on your team, I want to start to talk about the actual mechanics of the closing. So the first thing is closing documents. There's a lot of documents that go back and forth at closing, buyer to seller, seller to buyer. Amalia, what are the essential buyers and sellers documents that you need for closing? And I understand it may depend on the deal, but sort of what are the ones that are most important?
Yeah, the ones that are more important are the standard, documents for closing. If it is owned by a company, then you want a resolution, certificate of good standing, incumbency. If it is an entity behind, the ownership of the vessel, you need to require the same kind of documents. And the reason being is you want to make sure that whoever is executing documents on behalf of that company, on behalf of the seller, is authorized to transfer title. And then besides that, the certificate of documentation, Florida title, registry, whatever is on, the current registration of the vessel. And very important, tenders. Oh my goodness, tenders, jet skis become a nightmare for everybody. Please make sure that you get all the information beforehand so that when it's ready for the closing, it's not a surprise that you're gonna have that there's no title available, we can't transfer title, and everybody gets really upset because of the tenders. And so that we can start the process once we get the information, available to us.
On tenders, I mean, if you as brokers have those registrations handy, or at least know sort of the make, model, year, length, and hull ID number, that makes our jobs a lot easier, because then when we're not scrambling the day before closing to send somebody out to take a photo of a hull ID so we can prepare bills of sale, that is a huge help. And then in terms of the documents that have to be generated and signed for closing, what are the things that the registry is going to look for, the buyer's chosen registry? Resolutions, bill of sale? Resolution,
bill of sale. If it is a brand new boat, let's say a certificate of non-registry if we're going foreign. And then, of course, the forms that we have to prepare in order to register the vessel. Mm-hmm. And tonnage certificate if it is over 79 feet, and certificate of survey. And the question on, I know that it's going to be touched later on the EIAPP and EPA certificates, that is becoming a really, it's been put on the documentation side, which is not really part of the documentation process. Some of us really gets it, if it is available. If not, we advise the client that they need to get it, for a future sale.
On the EIPP, I think that's something that, the registry typically, most registries don't ask to see.
Don't ask, no.
It's not something you need to register the boat, but it's something that often people ask for at closing because they think an onward buyer will want it in the future. One other thing you mentioned with LLCs, we talked earlier about sort of the cutoff point for when you should get a lawyer involved. I think when there's a corporate owner, often that's a good reason to get a lawyer involved because you have to prepare certain documents. The whole reason you put the boat in a company is to protect the owner from liability, to limit the owner's liability. And if you don't observe corporate formalities, filling out resolutions, authorizing the sale, you're putting the owner at risk because you make it more likely that if something happens, a court will disregard the company, pierce the veil, and make the owner personally liable. So it's very important when the owner is an entity to observe those formalities. And then the other thing you mentioned was a tonnage certificate. That was something Claudia touched on earlier, which is that 79-foot cutoff. Depending on whether you're going to go U.S. or foreign, you need to get a tonnage survey for the boat so you have the right tonnage certificate for registration. That's another reason why you want somebody with some expertise.
Correct.
To be involved. All right. Claudia, we've talked a little bit about what these documents are that you want at closing. Where should they be at closing? Who should be holding them? If they're being couriered, how should that work?
Okay, so if you're actually having a closing meeting, which rarely happens nowadays, but if you are, then your representative should have your closing documents at the closing meeting, and the buyer's representative should have the closing documents at the meeting, and you can interchange. If that's not happening, then if you have either a documentation agent that you both are comfortable with, many times I just carry your documents to Amalia or to Kelly, and they hold for my clients, in trust for my clients until I tell them you can let them go, you can register. Alternatively, if there are attorneys involved, usually we come to an agreement, a letter of undertaking where I hold their clients' documents in trust and they hold my clients' documents in trust. That usually.
And so in those circumstances, if for whatever reason it's not possible for them to get the originals to you in time for closing, under what circumstances are you comfortable closing on copies?
It depends on which ones we're talking about, but if the registry will allow me to work with copies and I trust the person that's sending them, I'll take an undertaking. I'm more likely to take an undertaking on warranty of title and some resolutions than I am on bills of sale.
Can you explain what you mean by an undertaking?
So it's essentially an IOU, right? It's a letter that says let's say David Maass, agree that I'm going to send these to you by carrier after closing, and I'll send you non-defaced copies at closing as soon as the wire hits, and it's an IOU, essentially.
And Amalia, most registries, I think, will accept copies for registration, but with an original to follow?
Correct.
So if let's say you get the copy and then the original never appears, at some point your registration is going to go away. Yeah.
Yes, it's very important. I know that, a lot of now, most of the time that we have working on copies, but it's very important that we get the originals, for the protection of the client later on, and provide the client, with the package later that the original is available.
I had something happen to me back in, I think it was last year, that happened for the first time. It was a very complicated closing. The seller's originals were being signed, I think, in Cyprus, and then being sent to us by courier. And I won't mention the courier service, but it rhymes with DHL. And we got the originals. I got the package, and I opened it. Swear to God, it was someone else's documents. It was like a Bahamian marriage certificate instead of a bill of sale for a yacht.
Oh my God.
And fortunately, the seller's lawyer was somebody I had worked with many times and knew well, and I called him and he said, "You're kidding me." And I said, "No, they're just the wrong documents." And so I accepted an undertaking because I knew he had a POA to sign the originals. But you can't always rely on courier documents. Jason, you were going to say something.
Yeah, Ringo here, just wanting to slow things down a little bit. Of the documents you're speaking about that are necessary to absolutes to have at closing. There's some terminology that's kind of going back and forth here that in your world, that language is very easy to understand, but for the brokers out there that, 98% are going to be doing a U.S. documented boat, Florida title boat. It's the layers of ownership, corporate ownership, the registration, the separating those two for the cast of characters in the room may be an important thing. Because I think what you were talking about were two different points of ownership. One is who physically owns the boat, the entity that'll own it. That's establishing a corporation. And then where you register that, what flag state. So there's like kind of several layers we're talking about here. So, I think, again, what you were saying was you establish who owns it, and then you flag it. But you can wait for the flagging, you can wait for the registration part. The transfer of ownership can actually take place before you then take the new owner and then that registration takes place.
Correct.
I think that's what you were saying.
Well, and I think Amalia can talk about this, but you need to make a decision as a buyer about where you're going to register the boat early in the process, because that's going to dictate the form of documents that you present to the seller to sign. You're going to use a U.S. form bill of sale, a Cayman bill of sale, depending on your chosen registry. So that's something you can't necessarily wait until after the transfer to decide where the buyer's going to register the boat.
It is very important that when we either call, the broker call us or the closing manager calls us and say, we have a deal for you, we need to know in advance where the buyer is going to register the boat. If not, they can provide us with their phone number and we'll talk to the buyer. And then they will advise, this is where we're going to register, and that's what it will guide us on the proper documentation that we need to prepare for registration.
And on the seller side, not only the bills of sale, but also corporate documents such as the resolutions authorizing the sale. Often the registry will want to see specific language in those resolutions.
Correct.
You have to get them approved ahead of time.
Yeah, on the foreign side, not on the Coast Guard side, but on the foreign side, yes. If you have the resolution, power of attorneys, they're not very specific, they're more of a general power of attorney, then it's not going to be acceptable by the flag. You need to run it by the jurisdiction where the vessel is going to be registered to get it approved.
So if you have, let's say, the vessel's owned by a company, you would need, obviously, organizational documents for that company. You need a good standing certificate or some evidence that the company is valid in existence. You need resolutions authorizing the sale. And then when do you need a power of attorney?
In the event that, let's say that the buyer's not going to be available, the seller's not going to be available to sign, or the buyer's not going to be signing documents, so you need a power of attorney authorizing that person, and you need to show the registry also the resolution backing up that power of attorney.
Because it's not only the power of attorney, but you need a corporate action in the resolution authorizing the power of attorney.
Correct.
Right.
Even on like a state title book, like we have multi-million-dollar center councils now, so even though it's gross tonnage and LOA is small, the value of the boat is so expensive that maybe that owner wants corporate layers of protection there. Does this, what you just described there, play into even the small center council boat?
Yes.
Where the resolution's necessary? And
If there's a corporate entity, yes.
And especially, when you have a state registration, if you do not have the proper documentation, then it becomes a problem. If you have somebody signing as an attorney, in fact, on behalf of the company, you need to provide the state a copy of the driver license of the owner, as well as the person that is signing the forms on behalf of the entity.
Selling the boat.
Either the seller, the buyer, depending on which side. If you have a bill of sale signed under a power of attorney, and the state wants to see, or a title signed under a power of attorney, the state wants to see that original power of attorney, that person that signed that power of attorney. If it is an entity, you need to provide backup documentation, corporate documents, as well as the person that is signing. So it's now it's becoming, Florida used to be like you sign it and they didn't care. Not anymore. Now they want backup documentation supporting what you are presenting to the state.
That's a key sentence. That they've changed their position.
That's correct.
Like the FTZs, which you're going to get into. A lot of this stuff, and for what it's worth, of all of the seminars, I've been doing these for 20 some years, This one in particular, this transfer of ownership conversation, is key to what we do as yacht brokers in this entire industry. I can't think of a more value that we provide to the buyers and sellers is to know exactly what we're talking about right here.
And the other example you threw out that I think is important, we refer to sort of a cutoff at 79 feet. Obviously, that's just a rule of thumb, and there are exceptions. And we've seen, center consoles, custom sport fishermen that are below that point that are multi-million-dollar boats. And when a client comes to me with one of those, I say, it may not be that big, but you should put it in an LLC. And then it makes sense to get a lawyer involved because you have these sort of formalities that you have to observe, not only for registration, but to make sure that the company is going to be protected. When we have these documents, not only is it important to know what documents you need, but there are certain authentications that are needed in connection with those documents. Sometimes they need to be notarized or even apostilled. Amalia, how do you know which of the closing documents needs to be authenticated with a notarization or an apostille?
Most of the, when you deal with foreign transactions, that's when they require to be apostille. Meaning, if you have, let's say the vessel is they're buying a vessel here in the US and it's gonna go to Panama, let's say, or it's gonna go to Europe. Most of the European, they wanna authenticate that the person that signed it, as well, the notary that also authenticated the signature of the person signing it's authorized to do so in the state on behalf of the seller, correct. And that's where you have to go and authenticate the document and obtain an apostille at the state where the vessel was, the notary executed the form.
And even U.S. documented vessels, if for whatever reason the bill of sale is being signed abroad,
that's correct.
You have to get an apostille.
You have to get it is not acceptable to U.S. Coast Guard to have a foreign notary for documentation.
Explain maybe for people who haven't had the pleasure of dealing with that process what an apostille is.
I know that process.
Bless you.
Yeah, the apostille is a certification of the notary saying that notary is a valid notary authorized to execute documents on behalf of that state or country.
And in the U.S., typically you have to go to the Secretary of State's office in the state where it's signed to get that.
That's correct.
And if it's other countries, Jason?
That seems complicated.
Yes.
Yes.
It is.
The
It
States
is.
is not as bad. If you have to deal with a country to get it apostille, that can
It's
take
a nightmare.
longer period of time. And then also if you get it notarized by, let's say, in Mexico and it's notarized in Spanish,
You have to translate.
you have to get it translated, then apostilled. And just keep in mind it takes a little longer.
Sometimes lawyers in Europe like to put apostilles or require you to provide apostilles for everything, whether the registry requires it or not, and you have to ask them, do you really need this? Because if you don't really need this, it's going to delay closing to get an apostille because it can be a time-consuming process. Signers, the people who are authorized to sign on behalf of the company can be all over the place. Sometimes they are not in a position where it's easy to get something notarized. Claudia, how do you handle a situation like that?
Okay, with proper planning, items can be fixed. So if you know from the get-go that whoever has authority to sign is either not going to be available or it's not going to be around the notary, just tell the doc agent or the attorney that you're dealing with plenty of time, and there's things that can be done. You can either name an officer, somebody else that's going to be available to sign, and that will solve the issue. Naming the officer doesn't have to be notarized. And alternatively, now e-notarization is becoming much more usable. Many registries are accepting it, so that's usually not as troublesome. You just need to have an access to a phone or a tablet or a computer with a camera, and there's about 2 to 3 or more now companies that offer that service. So you can have it done in like 15 to 30 minutes. So it's really not an excuse. That being said, some registries don't accept it. I think now Marshall Islands and the U.S. Coast Guard accepts it, Amalia, but
Yeah, the Coast Guard accept as long as there is a certification by the notary, yes.
And you're talking about e-notary.
yeah, so basically it's a little stamp that says,
Like e-signatures that we use in
yeah,
yacht closing.
so you have an e-signature, but let's say the bill of sale. It has to have a little stamp that says
There's some numbers or something.
Yeah, it has a number, and then it says double authorization via video or it's some magic language that they accept it that way. But I don't know that Cayman has gotten around to accept it.
Cayman, it's BVI doesn't accept them. Now they're passing the law. Supposedly everything has to be approved by the government, but they don't accept so far, no. And Coast Guard you have to make sure that whoever accept e-notarization, that they have, like Claudia says, that little number, and or a certificate attached to the bill of sale that says, there is some language that they use, and it says that he has been, video camera and certified, they saw the guy and all of that. If not, Coast Guard will bounce it back completely, yes.
Claudia, the one thing I didn't hear you mention was power of attorney for if the authorized signature can't be. That was the question, right?
Yeah, the thing is, a power of attorney needs to be notarized.
Right.
So if the person that can sign the power of attorney and could have signed all those documents, the issue was they didn't have access to a notary, then the power
Got
of
it.
attorney doesn't necessarily solve that issue unless you e-notarize it, and then the registry will accept it. But that's a 50-50.
And that's also, you mentioned that if you plan ahead, you can get around these problems. At the beginning of the transaction, it's not unusual for a lawyer to say, I want a sale power of attorney. So if there's anything that needs to be signed, whether it's a bill of sale or even an amendment to the purchase agreement, an extension, something like that, I don't need to chase you for a signature. I can sign it in my office. But that's something that you have to get at the outset. It's not a solution if the day before closing you discover that the person's unavailable
Right.
to sign.
Do you guys give the captain's power of attorney ever?
So there's a few different
Delivery.
powers of attorney. Yeah, we've so far been talking about sale powers of attorney. A power of attorney to sign documents to transfer ownership of the vessel. At closing, there's a second power of attorney, which is the delivery power of attorney. And that's usually limited to signing the protocol, delivery, and acceptance, which we'll talk about in a little bit. But that is a much narrower authorization. Rob always says to clients, we just need somebody with a pulse. It can be your captain, it can be the other guy's captain. They're literally signing one document. So when it comes to a delivery power of attorney, those are two separate powers of attorney. One other thing I just want to mention for people who haven't been with have not done e-notarization. What is that like for the signer? Is it basically like a Zoom call?
Yes.
Yeah.
It's extremely easy, assuming they have actually, let me back up. Assuming they have good internet, it's extremely easy. It should take 15 to 30 minutes. Once I did it, and I usually try to participate in the session with my clients, and I send them the Zoom, and I couldn't get in, and 5 minutes later, my client tells me, we're done. So it's, even if you're not there, the person that's actually notarizing the documents, it makes it extremely easy. So again, 15 to 30 minutes tops if you're either having some issues or you're really notarizing a lot of documents.
Did you bill them for that time you weren't there?
I was doing something else.
Okay. Just checking.
You didn't answer the question, though.
I was doing something else for them, so yes, I billed
Okay.
them.
Okay. All right. We've talked about closing documents. Now I want to talk about sort of flow of funds, how money moves at closing. Typically, you have the deposit, which is paid a few days after the agreement is signed, either to the selling broker's account or, if there's a lawyer involved, to the buyer's lawyer's account. Obviously, you have the balance due at closing. Jason, how does that usually work? How does the money move around closing?
Okay, so again, with the different types of transactions you're talking about, if we just take the most simplest, like a U.S. Coast Guard document transaction, if we would ask our clients to hire Amalia or Claudia, depending on how it would work, and we would have the paperwork set up. Somebody would have sent all of the signed, the seller would have sent all of the signed documents that he needed to transfer ownership and given them to the independent third party, i.e. Amalia or Claudia. And when she has them, normally the funds are already set up, ready, triggered, ready to go. And she goes, I've looked at everything, it's all signed in the right spot. Please, you guys stop me if I veer off here.
Good.
But everything's ready to go. We go look over at the buyer and we say, trigger the funds. If we're offshore, We're all sitting out there bobbing like a Rice Krispie in the middle of a big bowl of milk, and we're waiting to hear, I've got my money from the seller. And once the seller says, I have my money, we look over at the buyer and say, congratulations, welcome to the nightmare, you're a yacht owner. And that's kind of how the transfer of money takes place. Somebody wants to see that everything's been signed for that transfer first. And then once that's been given the green light, yes, everything has been written perfectly, then you send the money.
So the simplest case is just a direct wire transfer from the seller to the buyer. And if it's a domestic wire, that usually takes less than an hour. And so even for an offshore closing, that's not an issue. You can wait on the boat until the money hits.
Correct. And I would say, again, going back to if we want to work with the bell curve here, the majority of these situations are going to be a boat sitting at a dock, probably the seller's dock. And then that transfer of ownership will have taken place financially and on a registration level, a title level. But the seller still has possession of the boat. So that comes into a whole nother area of complexity, which I believe you guys kind of have a lot to say about.
The master over there.
Well, right now I just
But
want to
yes.
talk about money. We'll talk about the complicated stuff.
But the money part would be once she's given the approval or she's given the approval that everything's been signed appropriately.
And what happens with the deposit?
Well, the deposit is dispersed either for the brokerage commission or any balance that's left over to be paid, at the exact same time. You want all of those disbursements to take place so the accounts are just empty.
And okay, so we started off talking about the simplest case. Boat's either at the dock or an offshore closing, but it's here. The money's just going domestically from buyer to seller. Sometimes with larger boats, it gets more complicated. You have an offshore closing, say, off France or Italy, and the seller's account is in the EU. But the buyer is, say, an American. And so you have different time zones, but timing is very important because you have, like you said, folks on the boat sort of bobbing around. Claudia, how do you handle the flow of funds at closing in a situation like that?
Usually we handle it in one of two ways. Especially if you're in Europe, they're essentially 6 hours ahead of us, right? And if you're in Turkey or somewhere else, 7, 8, who knows? So it becomes almost physically or practically impossible to get them the wire from the US and have it and be received in Europe at the same day. So your options are either find a third party that will hold the funds in escrow in Europe for you and is in a position to send the funds that morning in European time so that it can be received. And there's a couple of companies, some attorneys, some VAT advisors will do that. Option number two is if there's attorneys involved, we'll sort of do a switcheroo. We'll say, I'll hold your documents, you send them to me. I'll have them in the US and I'll hold them in trust for the seller. And in exchange, we will send you the funds to hold on the buyer's behalf.
This is as if you're representing the buyer now as a lawyer.
Yes.
Okay.
And, let's call it Hill Dickinson. And Hill Dickinson will hold the funds for us in trust for the buyer, but they will already be in Europe. And so we'll also say, and guess what? Once you receive the funds and we authorize you to disperse to the seller, we're closed. We don't have to wait for the seller to receive the funds, which may be an added layer of complexity. And that way they can just go offshore, sign the protocol, and be done with it.
And that's something that it has to be a firm you're comfortable dealing with, that you trust
Yes,
and hold the money, and obviously it's
absolutely.
something that your client has to get comfortable with.
Yes, because it's not risk-free, obviously.
right.
But the alternative is you might not be able to conduct a closing in a way that will save you VAT.
And there's usually either something in the purchase agreement or even a separate escrow agreement or a letter of undertaking. There's some way that that's documented.
Yes.
That this is what we're doing with the money, and until we tell you to release it to your client, it's still ours.
Exactly. Yeah, usually, like you said, either an escrow agreement or most likely just a letter of undertaking from both firms.
And that's one reason why it's good that there are a lot of sort of repeat players in this business, and we have firms that we deal with all the time, and we can work out these arrangements with them. But sometimes if you're dealing, say, with the seller's personal lawyer who's never done a yacht transaction before, may not be an option, and you have to look at a third party
Yeah.
to act as an escrow agent. Okay, so something we sort of alluded to a few different times, but I now want to talk about sort of more directly is offshore closings. Jason, you talked about it a little bit, but typically what happens at an offshore closing? How does that look?
Well, there's the reason you go offshore, and again, I really feel like I'm the least qualified up here to discuss this. But from the layman's perspective on why we go for an offshore closing, it would be for legal tax avoidance. And it would, do we want to go out of the state of Florida? If the boat will not be domiciled in Florida, we'll go off 3 miles. But if you don't want to lose your duty and paid status, we'll stay inside 12. And again, I love this seminar because I think this is an evolving opinion of the taxable jurisdictions that we navigate through. And so why we go offshore is in large part how the new owner will want to own the boat, the buyer, in this essence. So if we're offshore, we leave the dock, you've clearly got the signed paperwork that says it's illegal. Once you push it over the table, we've got all the money. You say, okay, get offshore. We're now between 3 and 12, so we are not. We're going to do an exemption affidavit for the state of Florida because we're leaving. We're not paying the cap, but we want to keep our duty paid status, and we're going to register in the Marshall Islands, something like that. Captain takes us out. We're there. We do the protocols of delivery to show where we are on the face of the earth, which half of you guys know exactly what I'm talking about, and girls, we take that. When the closing takes place, a new captain then takes over the helm and brings us back, and it's the buyer's boat.
You take some photos of the GPS, you make a note in the log.
Yeah.
And one thing that amazed me when we did our prep conversation, why do we do that?
Why do you sign a protocol?
Yeah, why do we do the photography?
So, Amalia, is the protocol ever shown to the registry? Is it ever recorded anywhere?
No.
No, it's not an official document. So the only reason you sign a protocol, and I think on a prep call, the way you described it was very apt. You said it was a defensive measure. If in the future the state of Florida or CBP comes and says this boat should have paid tax, this boat isn't duty paid anymore, the protocol delivery and acceptance is a document that you can show them that proves that the boat closed, the ownership transferred at this point in time and at this place geographically. So if you close outside of the taxable jurisdiction of the state of Florida, you didn't owe tax. The situation with customs is a little bit more complicated because my understanding is that, in fact, you can close in international waters without losing your duty status, provided you return immediately to the U.S. And in fact, the situation with the state of Florida is a little bit more complicated because, in fact, the territorial limit of the state of Florida isn't 3 nautical miles from shore. It's 3 nautical miles from shore or the western edge of the Gulf Stream, whichever is further. So you can't just rely on 3 nautical miles. You have to know where the Gulf Stream is on a given day, which seems ridiculous that should be the territorial boundary of the state of Florida. But believe it or not, it's in the state constitution.
Yeah, and sometimes it's 11 nautical miles.
Yeah, it can be.
25.
Now, the question I have is, if it's more than 12, is it possible for the state of Florida to assert jurisdiction outside of the territorial sea of the United States?
I mean, I don't want to get too legalese, but I would imagine probably not.
Probably not. But our Constitution says that that's part of the state.
And you have to be very careful when you do those delivery, because it happened to me one time. I was working with counsel, and the captain that took over a day later, let's say it was a new captain, came to the office and said, this vessel wasn't delivered in whatever position. And I'm going, I don't know. So I say, what do you mean? Where are you basing this information for? And he said, well, look over here. He brought this map, and he says, look at this, 3984, whatever it is. And it was delivered at the airport in Miami. And I'm going, what? And I'm going, are you sure? And we're going through, he says, look at this, and I don't know, whatever he did. So my responsibility was to call counsel and said, we have a problem. according to the captain, I don't know anything about boats, only documentation. He said that this boat was delivered, out at the airport.
So the Latin long on the protocol delivery, they crossed at the airport.
Apparently.
Okay, that's hard.
So,
Someone's
and I'm
screwed.
going, so the attorney was livid. So he called the broker, and he asked the broker, where did you deliver? Oh, in, whatever, offshore, in this coordinate, whatever. And he goes, did you really go offshore? And he goes, yeah, we went offshore. And he says, oh, really? Last time I checked, I don't think the international airport in Miami had any, waterways or. And he says, oh my God, it was like not a good scenario for the broker. And he forced them going out. I don't know what that was going to make for the buyer, but whatever, to have a new protocol backdated, don't even ask me. And for protection for the buyer, I was like,
I love this.
I would pay the tax. If that were me, I would just pay the tax.
I was like,
Yeah. I would much rather pay the tax than advise my malpractice insurer.
exactly.
That
But I was
happened.
like, I'm not speaking. I'm not counsel. I said, I didn't even want to hear that,
Yeah.
This is in Florida, not in Europe.
Exactly.
Right. Yeah. In Florida, since the tax cap went into effect, I mean, it closing offshore just as a tax avoidance strategy makes a lot less sense.
Absolutely.
I mean, there are valid reasons to close offshore, but it's not like it was before the cap when
Yes.
it made a big difference.
So you have to be very careful sometime, because when you have maybe brokers that might not know the latitude and longitude, like me, that's not our job, but make sure that at least you go, as they say, more than 3, whatever.
I got a question real quick. This protocol of delivery that no taxable jurisdiction solicits, that we've come up on our own as an industry, as a defensive measure, that we really don't need until someone may or may not ask for it in the future. Also, the other thing that we do is the helmsman swaps on an offshore delivery. Whoever was in command of the vessel on the way out, you need to hire somebody or bring back under command of the new ownership. Did we start that also? Is there any kind of legal precedence for that? Like, why are we doing that?
Legally, I mean, I think that's more of a liability issue, is if the seller's insurance expires when he transfers ownership and the seller's captain isn't insured under the buyer's policy, when the boat comes back in, you don't want to have a captain who hasn't been approved by the new owner's insurer in case something happens.
I like that answer.
I think it's more of a liability issue because the registry doesn't care.
But it's also, doesn't it also for the Department of Revenue, as you stated, that is, if they have to prove that they didn't collect the sales taxes because of the vessel was
Transfer
in
of
Florida.
ownership.
The other thing I want to talk about, it's not really offshore closings, but it's something that's in the same sort of ballpark, and it's been really popular lately, so I wanted to touch on it, is foreign trade zones. Foreign trade zones have become a really popular way to show boats that are not duty paid or maybe can't even be imported to market them for sale in the U.S. In the early days of the FTZs, you could close in an FTZ. You could do everything from showing to survey and sea trial to closing. But that's changed. Claudia, do you want to talk about that a little bit?
Yeah, customs really messed us up. So when it first started, 5-7 years ago or so, you could do everything at the FTC, Bahia Mar or LMC, let's call it. But about 3 or 4 years ago, customs came up with a ruling. I guess they woke up on the wrong side of the bed and decided, yes, you can do everything, but now you can't close at the FTC. You actually have to clear out the FTC bond and close in Bimini, wherever you want to go.
This is a big deal, by the way, because this just changed. Like, this is an evolving, like the people in this seminar, this is a good thing for you to pick up what she's talking about right here. This is big.
Thank you. And so if you close at the dock at the FTC, not just duty, but potentially your entire bond would be due, which I understand is quite a bit more. So there's one exception to that, which is, I wouldn't rely on it, which is sometimes customs will grant you case-by-case permission to close at the dock. And that usually is when the buyer's going to pay duty. Bearing that, you have to go close the bond and close in bimini or whatever.
Because when you close the bond, you have two options. You can either export the boat to clear out the bond, or you can import the boat.
Right.
So I guess if the buyer's going to import the boat anyway, you can work out a deal with CBP where they'll...
Yeah, on the buyer's perspective, from the buyer's perspective, we're going to pay duty. Why are we going to put the hours on the boat to make the trip? It's an extra liability for everyone. And so we ask customs to pretty please let us close at the docks, 50-50, they'll agree.
And if you're not doing that, sometimes brokers will ask, well, if we leave the FTZ, can we just go offshore and close and come back?
No.
No, the answer is no, because you have to go to a foreign port to clear out the
Yes.
bond, which means you're going to the Bahamas.
Yes, absolutely.
Okay, so that's foreign trade zones. Well, one thing I just want to return to quickly on the protocol, delivery, and acceptance. We talked about sort of when you need it, who should sign it. Amalia, I already asked you this, but it does need to be notarized because it's not being filed anywhere, right? There's no registry that requires it, so.
Well, on the protocol of delivery and acceptance, it requires notarization.
It's
Now
more
it's
of-
like I have seen it
It's a
both
good
ways.
practice. It's more preventive than anything. It's just an extra added protection that says, yes, we really signed this and we were here, and then there's a notary that says, yes, I saw them sign it. But if you're closing offshore, you're not going to be able to take a notary with you. So usually what we end up doing is we have two sets of documents that are pretty much the same, except one is called the Declaration of Delivery and Acceptance, and the other one's called the Protocol of Delivery and Acceptance. The declaration will have it either with witnesses or without anything, just a simple signature. You'll go offshore, you'll take your newspaper if you're still one of those. Make sure your boat has a GPS, because that's happened to me. So for some reason it wasn't working and nobody decided to tell us. So you go to wherever you need. That's the day you check where the edge of the Gulf Stream is, which varies. And you go to your location, you sign the declaration, take your pictures with the GPS, the newspaper if you have it, come back. Then you find a notary and fill out the protocol of delivery in the same way you filled out the declaration, and just sign it and be done with it.
And we've been talking about protocols in the context of offshore closing, but obviously you don't use them just in offshore closings. Even if you're closing at the dock, there are
Yes.
reasons you would want a protocol.
Yes, I fought with some attorneys about why I would sign a protocol. Again, preventive. Once you deliver possession of the boat, your seller's off the hook, your buyer's insurance starts becoming on the hook. So it's a nice document to have to document the date and the time where possession transferred. And so that way, if, God forbid, something happened 10 minutes after, then you know whose insurance is on the hook.
Well, you could also have a boat, say, that's imported, duty paid, that the buyer's paying sales tax, but you still want to show that it closed in the U.S. because you don't
Yes.
want to lose the duty status.
Correct.
In fact, even if the boat is U.S. built,
You can lose
you could lose the duty status and bring it back in as U.S. goods returned, but it's better to have a piece of paper than to have to pay a customs broker to do a U.S. goods returned
Exactly.
entry. Okay, so we've talked, I think, about everything I wanted to talk about, which was assembling the right team, documents, money, offshore closings, and then protocols of delivery and acceptance sort of as a part of that. I think we have a little bit of time for questions. If people have any questions, anything they want us to talk about.
There's a question over here, but could you wait for the microphone, please? So everybody can hear the question. Sure. You got a first question? Here. Paul.
Right here in front.
Good morning.
Good morning.
Thank you for being here, speaking to us. Question for you all: if a foreign boat is in an FTZ zone, and the boat is in a corporation, and the buyer is buying the shares of the corporation, can the boat close at the dock?
Interesting.
That is an interesting question. That is not one that has come up for me before. Claudia, have you seen that?
I have not seen it. I would say customs may still come after you just because they're a painting the boat.
I definitely would not be comfortable doing that
would
without
not be
something in writing
comfortable.
from customs
Yeah,
blessing
agreed.
it.
Agreed. Technically, you're transferring the shares. I think an argument can be made where you're transferring the shares and not the asset, but I wouldn't feel comfortable doing that.
This FTZ thing is, it's fantastic, and I applaud the IYBA for spearheading this with U.S. Customs 7 years ago when we were trying to figure out a mechanism to be able to have American money involved in foreign flag boats that had not had duty paid. This is a brilliant move, but it's evolving. Just last week I was involved in one, and for what FTZ used to be able to, the marina would pick up the phone call and say, we've got these docks as an FTZ zone. That's not the way it is anymore. They have to declare a specific slip, which the boat you want can't be in when two customs agents come out, measure the slip, then put a sign on it that designates it as an FTZ. Then your boat comes back in. Now you can do commerce with U.S. citizens for that non-duty paid vessel while it's in that slip. Then when you want to close, you got to leave the slip, and they've got to come and see that the boat wasn't in the slip and that she left, and then you've got to clear customs coming back. But that opinion may change as this is evolving. So it's a wild ride, but it's definitely worth it.
My experience with FTZ and sort of how it's evolved is that it's been really great for the industry, but the problem is it clearly wasn't designed for yachts. No. And so Customs and the Department of Commerce who administer it just sort of have been making it up as they go along.
When we first started it, they wouldn't allow crew on board. You can have your boat there, but we can't have anybody living in the boat because at FTZ zones at airports, they never had anybody living in the cargo, compartments. But we were like, no, our cargo holds people. And Customs was like, we'll get back to you on that. Let's think this through.
And we need it for insurance.
Yeah. And so they worked with us. It was cool.
And just an added, I kept on thinking about it. Even if Customs says yes, then your buyer is still responsible for finalizing the bond and making sure those terms haven't been dealt. So if I was a buyer's attorney, I wouldn't take on the liability.
That's a recurring issue with sales of shares as opposed to a sale of the asset, is that it seems like a nice way to avoid, say, a tax liability or some other issue. But when you get into all the sorts of liabilities that can go along with a company and negotiating reps and warranties and indemnifications from the seller, often the closing costs are much higher than they would be if you just
transfer the asset.
bought the boat. So
two-part question. Who would be responsible for checking where the western edge of the Gulf Stream was after an offshore closing? And the second part of that would be, who was responsible, is the captain measuring current and water temperature differences to find the break of the western edge of the Gulf Stream? That seems ridiculous.
Yes.
David?
Yeah. So the answer is yes. The captain is responsible, sort of as a practical matter. The second part, yes, it is ridiculous. There is one reported Florida case on this, and it involved a casino boat going out of Jacksonville. Somebody was injured when the boat was more than 3 nautical miles offshore, but before the western edge of the Gulf Stream, and the court just looked at meteorological data from that day to determine where the western edge of the Gulf Stream was. So it's a fact question, and it could be contested. But yeah, it's ridiculous.
It's extremely low probability.
Yeah. Yes. Yeah.
I would add to that it's in the buyer's interest. Typically, you go offshore because the buyer doesn't want to pay taxes, right? So it's in the buyer's interest to make sure that you are where you were supposed to be to not pay taxes, or you're going to have to pay them later with penalties. Usually what I do is, I forget what it's called. There's a website, I think it's NOAA, and they estimate every couple of days where the Gulf Stream, where the edge is. So you can go there, use it as I think you tried, sort of. But that's basically all you can do.
You get keel hauled if you get it wrong.
Good morning, Captain Jim Hayek with Passion Yacht Sales. I have a unique situation on a documented vessel. The vessel was documented. It's the first transgender that I'm dealing with right now. She was a female when they owned the boat. They have now transitioned to a mail. We're getting ready to go ahead and start the closing and the documentation. I'm not sure the best way to facilitate that. Would it be, I've had some good advice from some of these gentlemen here, but an affidavit of identity or
Is it individually
POA?
owned? It's owned by the individual, not the company? Not a company?
An individual, yes.
Oh, my God.
And they're legally changed their identity, now they're a male. So,
Did they legally change?
but the documentation is still in the female's name.
Did they change the name,
Legally?
I presume?
Yeah, change the name from her female name to her now male name. Laura is now Bill.
Right, but legally, did they change the name? Okay.
I love this
Oh,
business.
I don't know.
I love David's face, though.
In almost 30 years, I have never heard anything like that.
So sometimes you'll have a situation where somebody's name appears differently on two documents. You know, they used a middle initial or a middle name on one document, but not on the other. And in those situations, often you can prepare an affidavit that says
Yes,
these two
same
people
name.
are the same person.
Correct, but it's usually pretty much the same name.
Right. But I imagine, particularly if you had some sort of court document showing the
Right.
legal change of name,
Yeah.
you would be able to file that with the Coast Guard. And because, I mean, that must have happened before, say, with married names. I mean, people get name changes all the time, and that could happen between purchase and sale, and I imagine
Yeah, it
they've dealt
shouldn't
with
be
that.
any different.
Yeah.
Yeah,
should be able
but
to do-
usually, you know, what it makes it on our end, let's say on the documentation side, is that after the sale takes place, then we have to be dealing with the Coast Guard
Yeah.
that says, okay, that's very good, you know, it was Mary and now it's Paul, or vice versa. And then it's like, oh, I don't,
Amalia, I resemble that remark.
and now is, okay, you presented this documentation, but maybe, you know, we are at the expense of Coast Guard that says, I don't accept this, or you have to go further and ask the seller to provide, I don't know what, the counter document. I mean, that will be a unique situation for Coast Guard. But, and then what happened then for us, you know what I'm saying, as well as for the buyer? Because it's like, I wouldn't like to take that responsibility. If it is, let's say, a vessel under 79, I wouldn't take the case unless the seller, who is now, you know, whatever, will change the documentation with the U.S. Coast Guard and transfer title to the buyer.
Yeah, I mean, the
because
problem-
I don't take that responsibility on behalf of the buyer. No.
But then you're waiting 2 or 3 months for NVDC
Well,
to issue a
you know,
certificate of
unless,
documentation.
well, you know, you can say to the Coast Guard and see if they approve it that, you know, there is a closing and due to a situation like that, the sale cannot take place. And if Coast Guard says it's not on my problem, they will reject, then what do you do? Because what happens if Coast Guard says, I don't accept this bill of sale? Then you're stuck.
This is a problem that comes up is it's always better to deal with this stuff before the sale.
Yes.
People wait until they have to sell their boat to clear up some issue in the way it's owned, and then it becomes under time pressure and you lose the deal over it, and it's just terrible. It's always better to do it when the change
Yeah, get the
happens.
documentation before and then deal with that at that point instead of waiting until, you know, the sale takes place. That puts everybody on the spot.
We had a deal where it was a boat that was owned by a husband and wife in Cayman, and the husband had died, and he still owned shares in the Cayman company. And what we discovered then was that if you own shares in a Cayman company and you die, you have to have the estate resealed in Cayman. You have to go through the probate process in Cayman, which can take like 6 weeks. And we almost lost the sale over it. And the husband had been dead for several years, all because it hadn't been addressed at the time it happened. So when there's something that's going to affect the ownership, it's always better to handle it at the time of, as opposed to waiting until it becomes an issue in a sale.
Yeah, I was going to say, just as brokers, a really good habit to get into is when you list a boat, you start asking these kind of questions, especially if the corporation is in good standing or whether it's not in good standing. Because if it's not in good standing, it's a big hassle to get it back into good standing. But anyway, asking for all this stuff when you list a boat, it shows your professionalism to the seller right away when he's listing the boat with you, and then you've got weeks, months, days, or whatever to at least get a little bit of a head start on that. My real question, David, is can you give us a few of the reasons why people would register a boat offshore? Because with the $18,000 sales tax cap, obviously, the sales tax savings is really not
True.
the issue anymore, but there's a myriad of reasons why somebody would want to register a boat offshore. This would give us all a good chance to hear your hopefully quick answer to that.
Well, as a practical matter, I think right now the big reason is foreign crew.
Yeah.
It's easier to find foreign crew, it's cheaper to hire foreign crew, it's cheaper to insure foreign crew. And there were some changes to the Foreign Affairs Manual about 2 years ago that said that in certain cases you can have visas are available for foreign crew to work on U.S. documented vessels, but that change is sort of still up in the air. We don't have any written guidance from CBP on that. So as a practical matter, it's still very difficult, almost impossible for foreign crew to work on U.S. documented vessels, to get visas to work on U.S. documented vessels. And so the ability to hire foreign crew is the number one reason. Certainly for vessels under 300 gross tons. Once you get above 300 gross tons, as a practical matter, you have to register offshore. But I think for smaller boats...
What's that practicality, though?
The practicality is that under U.S. law, once you hit 300 gross tons, you're an ocean-going motor vessel, which means you have to comply with Coast Guard inspection requirements, which were not designed for yachts and which almost no yacht can meet. There is a narrow exception that was passed, it's probably 5 or 6 years ago at this point, that if you have an MCA certificate of compliance, you can be registered as a documented vessel, but you can only have a recreational endorsement.
So like a Westport 130, which is 333 gross tons, you would say that that should not be a U.S. Coast Guard documented vessel?
No, it shouldn't be. I would say, I mean, unless the owner really wants to have a U.S. documented vessel, and I don't think Westports are built to MCA, or maybe they are, but in any case, at that point you would want to go offshore. The offshore registries are much more sophisticated when it comes to dealing with larger yachts. They have sort of the technical expertise that the Coast Guard doesn't when it comes to yachts. U.S. law was aside from a couple of things here and there, U.S. law just wasn't designed for large yachts.
Are any of these opinions you're rendering on John's question based on a boat that is going to be doing charter, or is there a difference if the boat does charter work or if it's just private? And take that 130 Westport at 333 GT. If it's going to be privately owned and never do a bit of commercial work, do these U.S. coal regs come into play?
Yes, they do.
Yeah, it does. It doesn't make a difference in terms of how the U.S. treats the boat. When it comes to chartering, I mean, if the only way you can register above 300 gross tons is to have a recreational endorsement, that means that if you want to charter, you're going to be limited to bareboat chartering, which you could also do as a foreign flag yacht. So there's really no advantage to using that exception to register the yacht U.S. over 300 gross tons if your intent is to charter. You're better off just going foreign because you have to bareboat anyway.
Got it.
While we have two attorneys up on the stage, I was wondering if you two might be interested in telling, at least as an issue spotting, everyone about one, that first preferred ships mortgages will soon be recordable in states, not with just the U.S. government, and two, that the OFAC process and doing a little due diligence on their own end before accepting any deposit.
I'll let you tackle the first one.
So the first one, that's news to me, that you can have a first preferred ships mortgage on a state titled and registered vessel. Typically, they're only available for U.S. documented vessels, which is one reason many lenders require vessels to be U.S. documented so they can get the benefit of a first preferred ship mortgage. If it's state titled and registered, typically the only sort of security interest you can have in the vessel is just a UCC security interest, which is outranked by all maritime liens. So if preferred ship mortgages are now going to be available for state titled and registered vessels, that would mean, I assume, that lenders would be more comfortable accepting those and not requiring people to U.S. document. But that's not something that I have any experience with, so I can't really speak to. And Claudia, did you want to talk about OFAC?
I mean, I didn't, but I've dealt with it. So the first one, I agree with you. I didn't know that was a thing, but if it is, lenders are certainly going to be a little bit more comfortable with it. So the thing with OFAC, so the U.S. doesn't really have robust KYC, anti-money laundering regulations, but it has a sort of a catch-all, which is you're not supposed to be doing business with anybody who's in a sanctioned list. And so OFAC carries these list, and it's pretty easy to go online and check. You would basically table it to all sanctioned lists, and you put in the company's name, any person that you can see is associated with that company in there. And provided there's not a hit, then you should be good to go. If a hit comes or a potential hit comes up, like let's say Luis Manuel Rodriguez, or something along those lines, usually Hispanic names tend to be a problem. At the very least, I would get a resume, an affidavit saying I'm not this person, but it's a problem. It can be.
Can I throw out there that it's brand new? The Coast Guard just finished and published in the Federal Register what states will need to do to begin accepting. The reason we haven't seen it as a practical matter is because no states are yet doing it, but over the course of the next year, we should anticipate, because the CFRs are in place now to allow states to do that. On the OFAC, I just want to throw out something that scared the bejeebies out of me, which is in November, a month ago, we were in San Diego. We heard from the FBI agent in charge of tracking down assets, particularly when it comes to vessels, as well as the head attorney at DOJ. And the takeaway was that they essentially are outsourcing, because they don't have the manpower, to the private sector to do the due diligence. And what really frightened me is that they no longer accept that you've done enough due diligence on the beneficial owner just by checking OFAC. And they suggested that you purchase at $10,000 a license some specialized software, which even the registries, some of which, can't afford to do, and which is why they're pushing that to the attorneys, as they always have, to do the due diligence. So a little frightening for all of us, but I thought it would be interesting to know for this group that is going on and is being enforced.
Yeah, a year or so, and I think I had never seen it happen. I've never seen it happen in the maritime industry, but I've seen it happen in the airplane industry, where a couple of years ago, one of those title companies that does airplane transfers, their assets were completely seized. And so they basically had to prove to the DOJ that certain transactions were not tied to whatever it is the DOJ flagged them for. And I had a client was one of the deposits being held, and it took us like a good 6 to 10 months to get the money back. So obviously that transaction was killed at that moment, but just getting your money back can be problematic.
And Claudia, you alluded to this. This is an area of KYC and anti-money laundering where the EU is just way ahead of us. Most of the rest of the world, I think, is way ahead of us.
Yeah, absolutely.
So I don't know if we'll see a change in that in the U.S. side in the future, where we have to start getting those documents up front. But right now, it's still the Wild West.
We have time for one more question. Todd, my only recommendation is you should read more Danielle Steele. It's a lot less stressful than all that legal stuff that you're reading. Hang on.
Hello. Thanks for having this. This is awesome. I have a question. Actually, it's more of just I want to see what your opinion would be about this situation. Let's say the closing agent is just getting all the paperwork in. Let's say this morning. I'm on the boat. The seller is waiting at his house, waiting for me, and the buyer is the buyer's on the boat, waiting for the closing agent to get the package for all the original paperwork. The closing agent does not want to she doesn't want a tracking number, she wants to have everything in hand. Then I get on the boat, the money's in escrow, all the money's in escrow. I know technically we're closed as soon as the closing agent gives all the okay, but the seller does not want the boat to leave, as even though the closing agent has said everything is good, we're technically closed. Now I gotta go to the bank and send the wire, and the seller is like, no way that boat is leaving the dock. I want to get my money. I've been in this situation a couple times, and I've always handled it pretty well. But I'm just curious, like, how would you say to the seller, look, it's technically closed, it's safe, blah blah blah. Like, what's your thoughts on that?
So let me make sure I understand. The documentation agent has the original seller's documents in hand. The boat is at the seller's house or at the seller's dock, and the seller is saying, I will not let the boat physically leave until I have the money in my account.
Wait, and is it physically leaving for an offshore closing or just leaving his house? Oh, yeah. I mean, your seller's right.
Yeah, I think the seller's
Buyer's
fully
got
within
to
his
sit.
rights. Until I get paid,
That's right.
I'm not letting the boat go.
Yeah, your seller's right. My only exception to that would be if under the contract you're supposed to deliver the boat offshore, then the terms of the contract dictate that the seller has to physically take the boat offshore. And I believe, if you guys haven't changed it in the last time around, I believe once the money is, they don't have to do that until the money's in escrow with the
A
broker.
third party.
Under the EBO agreement, yeah. Under the EBO agreement, if the boat's going to move to a delivery location, you have to have the full purchase price
Yeah.
in escrow before closing.
But in his situation, where the seller still possesses the boat, and if you're his representative, I'm just spitballing here, guys, but I would say that if you're representing that seller and he doesn't have his money but still has possession of that boat, using the phrase, the closing technically has occurred,
It
I think is
hasn't.
inaccurate. I don't think that closing has technically occurred just because the agent's got the docs. That says that we're all signed. Because that seller still has possession of that boat, and until he releases that to the buyer, and the buyer then has possession, then you've got, voila, now you technically,
And
I'm using
yeah.
that word technically because that's what you used, and I want to be real specific on that. That guy still has possession of that boat, and if he gives you the marching orders to keep your butt on it until he gets his money, that's exactly what you do.
And he should do that. I mean, crazy things have happened with wires. I've had some held for weeks. So I understand the seller.
Yeah, it's. That's great, but it's
Not in his
not in the
account.
seller's
His
account.
account.
Yeah.
Even though it's in a third-party account, could be his attorney. If that's his position, then I kind of, as it's awkward. Don't get me wrong, and it sucks. And if it creates, and then that's a question. Now, if the buyer doesn't get his boat, and has the seller now breached the contract, and do we have a whole problem? I mean,
Unless you've agreed otherwise, until the seller's paid, he doesn't have to deliver the boat.
Exactly.
okay, and the whole, we work fortunately in a business that the intent is for a transfer of ownership. It's not a gotcha moment, so.
We done?
Well, that was fantastic. We let it run on a little bit because the information was so great. Let's hear it for these guys. David.
Thank you.